Hi, it's Lee from colouringqueen.net, and we haven't chatted for a while, so today I thought I'd colour in a picture from that lovely Scotch woman, Johanna Basford. And when I seen this picture, I thought I have to tell you a story. I'm colouring from Joanna's book this month for my Johanna January colour along on Instagram if you haven't already joined in. Thank you so much to everyone that has joined in. I haven't been able to reply to all of the Instagram tags in the last couple of days because I've had a few things going on, but I have been seeing them and they are just fabulous. And thank you so much for joining in if you are joining in Johanna January. Anyway, when I opened up Joanna's book, I mean, Johanna is so famous, isn't she? She has sold over 22 million books. Amazing. But she actually reminds me of another Scotswoman that I know, and I've loved her for actually longer than Johanna. And she's very famous in her own right. Although, unlike Johanna, she probably had no idea how famous she actually would become or be in her lifetime. And her family actually had no idea of how famous this woman is and the impact that this woman has had on the world after her death and prior to her death, and she will continue to have that impact. She is the reason that trillions of dollars have been spent throughout the world, and she's the reason that a lot of wrongs have been righted. Nearly got that wrong. There are restaurants named in her honour. There are bus trips organised from countries around the world to go to Scotland to walk her path. She's had statues erected in Scotland to recognise her and monuments. But a lot of people have never heard about her. So I'm going to tell you a story today, and it's about the first Scottish woman that I was obsessed with before I met Joanna's beautiful colouring books. So I'm going to tell you about May Donoghue. She's sometimes called Mary, and in her later life she was called Hannah May Bell. And she's often called McAllister as well. But McAllister was her maiden name and Donoghue was her married name. And I'm going to tell you why she's so important. So May McAllister was born on July the 4th, 1898, and she spent her whole life in the poorer districts of Glasgow. After a 12-year marriage, she'd had 4 children, but only one, a son, Henry, survived infancy. So the poor woman had lost 3 of her children, and I guess that's a reflection of the times. She separated from her husband at the age of 30, and she was living with her brother and working as a shop assistant and bringing Henry up on her own, and she was really struggling to make ends meet there. One Sunday night on August the 26th, 1928, she caught the 30-minute tram ride past Paisley Town Hall in Glasgow to go to the Wellmeadow Cafe, which was operated by Mr. Francis Minchella in Paisley in Glasgow, Scotland. So May Donoghue's friend, and it's been debated forever whether this was a female friend or whether it was a gentleman caller, has always been a little bit of a mystery, but the identity is often referred to as a she, but who knows? It doesn't really matter. She met with her friend in the cafe, and the friend ordered a pear and ice, which I've never heard of, but apparently it was a thing, and May Donoghue ordered a ginger beer ice cream float, which is often called a Scotsman's float. And her friend kindly paid for May's little treat. So the owner poured the ginger beer from an opaque brown bottle. So, you know, the bottles that beers or even ginger beer nowadays in Australia is served in, it's very brown and you can't actually see through it. But the bottle had a label on it from the Stevenson Ginger Beer Factory. And she poured it over the ice cream into the float, and when she topped it up and poured it from that brown bottle, where you couldn't see through it, a decomposed snail fell out. And that's why the picture of the snail in this colouring book reminded me so much of May Donoghue. And Donoghue said she immediately felt shock when she looked at the sight of this awful snail floating around in her ginger beer, as you could imagine, and she complained of stomach pains, and she was later taken to hospital and treated for gastroenteritis. Surely someone should be held responsible for her getting sick. I mean, this was a struggling single mother who had to take time off work to be sick and to get over that illness. So surely someone should be responsible, but who? I mean, should it be the cafe owner? But he couldn't be sued because at the time, under the law of contract, Donoghue actually didn't have a contract with the cafe owner because her friend paid for the ginger beer float. So what else to do? At the time, there was only a few areas of law where you could go to for relief and make a claim. There was personal injury, and that depended on physical damage directly or indirectly. And being made ill by the awful snail in the bottle didn't qualify. So it was of the view that she didn't have a claim in law. Under contract law, of course, she could make a claim, but she couldn't because she never actually bought the drink. But there were sometimes laws that related to things that were dangerous or known to the manufacturer to be dangerous, where she could make a claim, but they were for things like firearms and poisons, and so again, the snail in the ginger beer bottle didn't fall into that category. But May didn't let that bother her. She was determined to fight this case, and no matter what she had to do, or no matter what she had to argue, she felt that the manufacturer of the ginger beer, Stevenson, as per the label on the bottle, owed her compensation or a duty to know that she would be sick if he allowed snails to get into his manufacturing process. So she engaged the services of Walter Leachman, who was a solicitor and a local counsellor, and he took up May's case pro bono. He did it as a freebie. And Walter was very familiar with soft drinks containing little bonus extras because he'd already bought 2 cases against another drink manufacturer, again pro bono, alleging this time, hold on to your stomach, it makes me nauseous to think of it, a dead mouse that had been found in bottles of ginger beer. And in those cases, he said, in the first one, he said his clients that were 2 children had found the body of the decomposed mouse in their ginger beer, and they suffered injury and obviously stomach pains and whatnot. But the court said the injury that the children suffered was so slight that they really shouldn't waste the court's time with all of this. And they also felt that it would be a little bit difficult to squeeze a mouse through the narrow entrance on a ginger beer bottle, and that there would be no time between the time that the ginger beer was put in and the lid was fastened on top to get the mouse in there. And one of the judges, Lord Anderson, he said the odds of getting a mouse into the ginger beer bottle were millions to 1. So despite this, there was another woman also in Glasgow, and she also found a mouse in her ginger beer. And by coincidence, she also engaged Mr. Leachman to act for her. Lots of coinkydinks in this case. And unfortunately, the court, again, didn't decide her way, and Leachman lost both cases. But notwithstanding all of that, he still went ahead with Donoghue's case, when the only difference is the type of critter that's in the ginger beer. There's still something in it. And so he launched a claim against David Stevenson, the manufacturer of the ginger beer. And he claimed for the gastroenteritis that Mrs. Donoghue had suffered, and he also claimed damages of £500, which today would be about £25,000. And so, although the bottle was labelled with Stevenson's name on it, Stevenson claimed that it's possible it didn't actually belong to him. Bottles were often reused, and in the process they were often returned to the incorrect manufacturer. And Stevenson actually said he didn't even issue bottles matching the description provided by May Donoghue. But regardless of all of that, the lower courts dismissed the claim, and ultimately May decided that she was going to take this all the way to the top. May and her solicitor that had run many of these cases previously. And she decided that she would take it to the House of Lords. But in order to do that, you needed a few buckaroos. And May didn't really have any money, because this would be incredibly expensive. And even though her solicitor was acting pro bono, if they lost the case and the court made orders that she would have to pay Stevenson's costs, she wouldn't be able to do that. And in order to pursue the case, and so that courts avoid frivolous claims and what people are known as vexatious litigants, you have to have a security of costs, and which is basically an ability and a proven way to pay in case you lose. So an exception back in the day of May Donoghue was if you were a pauper. So you basically had to go through a legal process to say that you had no money and you wouldn't be able to pay. And in Mary or May's writ, she declared that she'd only £5 and the clothes that she was wearing. And once she was declared a pauper, she was then able to take this matter to the House of Lords. So Mary has really gone through it by now, and this is already 3 years after the snail was found in the bottle, or whether it was, whether it wasn't. So at the time, there'd been a lot of cases where similar claims had been made, and the courts had each time rejected them. But there were some judges that felt that the law was an evolving beast and it needed to reflect the times that we live in, and some laws needed to be changed. And one of those was Lord Atkin, and he's an Aussie. He was born in Brisbane, Australia, where I live currently, in November 1867, but at a young age he returned with his mum to Wales. Now, Lord Atkin was said to be very religious and very moral-minded, but he also had a bit of a sense of fun, and it was said at home he expected his children to treat him with great disrespect. Prior to May's case coming to the House of Lords, he'd made a number of speeches featuring a love thy neighbour theme, which is, of course, found in the Bible. At the University of Birmingham's Holdsworth Club in 1930, he said that the man who swears unto his neighbour and disappointeth him not is a person commended by the law of morality, and the law enforces that by action for breach of contract. So he's saying that, you should have morals. In 1931, a year after that speech, and a month before Donoghue and Stevenson was before the House of Lords, he also alluded to this principle of loving thy neighbour in a lecture that he gave at King's College in London. And he said a man is not to injure his neighbour by acts of negligence, and that certainly covers a very large field of the law. And he was basically saying, do unto your neighbour as you would do unto you. So again, going back to canon law, or church law as it's called. So you can pretty well guess that if Lord Atkin was going to be hearing the case of the snail in the bottle, that he would be pretty tempted to find in her favour, given his previous speeches about negligence and the morality of what he feels that the law should have been. And in his diaries, which have come to light in the last few years, he was super excited about the Donoghue case. And even before he was appointed, he said, I've learned that Donoghue was set down for hearing yesterday. And perhaps I should have a chat with Sankey about sitting on the panel. I don't know who Sankey is, but he certainly knew. And he said it might be just the venue to develop a more general duty principle in the law of negligence. And he also alluded that he'd been hoping to do so ever since he'd heard other cases, one in which a woman had been run over by a truck and she'd later miscarried. And because he was in the minority decision of the judges, that he couldn't change the law. So funnily enough, Lord Atkin actually did get appointed to hear Donoghue and Stevenson, and he was one of 5 justices or lords. And he wrote in his diary, I've learned that I've been assigned the Donoghue case, along with Buckmaster Tomlin, Thankerton and Macmillan. So a Welshman, which is what he is counting himself as, 2 Englishmen and 2 Scots. This should be interesting, is what he said. And a few days later, he said, in its own way, this is surely one of the most important cases to come before the House of Lords, because it engages issues of public health and the protection of ordinary consumers. And a month later, he said in his diary that he took a type of poll that at his church and among his family, and he said, I read the parable of the Good Samaritan in this morning's lesson at Aberdavi Church. I've probably butchered that name. And at lunch, we had an excellent discussion about who is my neighbour, which turned quickly to the snail in the bottle case. I'm pleased that none thought it too far-fetched to regard Mr. Stevenson as Miss Donoghue's neighbour, though perhaps this reflects the kind indulgence of family members. So it's pretty clear that Justice Atkin really wanted to expand the law and responsibilities, but he was only one of 5, and in order to effect a legal change, a majority decision would be required. It would have to be like 4-1 or 3-2. And the concept that he was trying to develop is actually a principle that's been around in law since the 1770s, some say the 1600s, that you should take reasonable care to avoid injuring your neighbour. And he was just trying to revitalise this principle. And during this period of time in legal history, this was quite common because the world had been through the First World War, and there was a general feel about being more protective about human life, and you can see it in a lot of cases during that time. And so it's said that the 5 lords got together to decide the case in a room overlooking the garden in front of a roaring fire and the River Thames. And while all of the lords agreed that there should be some sort of manufacturer's liability, meaning that if a manufacturer harms you, they should be liable to pay you some sort of compensation, it was the nitty-gritty that they all disagreed about. But it was Lord Atkin's speech that made legal history, and he basically identified a new area that attracted liability, which was at the time evolutionary. And he made the most famous statement in English law, and that is the rule that you are to love your neighbour in law. You must not injure your neighbour, and you need to avoid acts or omissions that will injure your neighbour closely and directly. That's basically a summary of a pretty huge speech that Lord Atkin made, and a very brief summary at that. I've missed lots of stuff out so as not to make this too complicated. Even with Lord Atkin's view, as I said, they still needed a majority, and it's not like Lord Atkin could persuade a lot of people because he was actually pretty unpopular. He often had to eat lunch alone because no one would eat with him, and I don't know, he must have been particularly persuasive, or maybe the other lords wanted this change as much as he did and hadn't documented it. But he was able to persuade Lord Macmillan to agree with him that this law should apply to the area of the UK and Scotland, and rather than what Macmillan wanted, which was Scotland only. And Macmillan also said that this law, it must adapt to changing circumstances of life. And he also said that the law of negligence never closes. Before this case, the law of negligence hadn't really opened to this extent. So this is all totally revolutionary, and it wouldn't have happened if May Donoghue hadn't decided to pursue this, hadn't gone through and become a pauper, hadn't fought it all the way to the House of Lords as a single mum, if she hadn't have found the only solicitor around in all of Glasgow that not only had experience with these cases on the losing side, but also was willing to take it on pro bono. So in the end, as you might know, the majority of Lords, 3-2, decided the case, which basically invoked what we call the neighbour principle nowadays. And then the case was sent back to the courts to decide on the facts and look at the evidence. Because when they were deciding on the law and that it applied and that manufacturers should owe somebody a duty and that they were liable if they suffered any harm or loss, they hadn't actually looked at the evidence to see if there was actually a snail there in the first place. They assumed that there was. But unfortunately, before this matter could be heard and decided if there was actually a snail in the bottle or not, and what Stevenson's defence might be, Stevenson actually died. And his estate was left to deal with finalising this case against him. So the estate ultimately paid Mrs. Donahue £200, and this would be about £15,000 today. She was originally claiming £500, but she got £200 out of it. And everyone, I guess, went away and did their own thing. Donahue never realised the extent of what her contribution made to legal history and to laws all around the world. And it was the case that paved the way for many other cases and expansion of the law of negligence in Commonwealth countries. It evolved into manufacturers and product liability, medical liability, physical liability, and even pure economic loss, where you just lose money. Extended to cover both acts, things that you do, and omissions, things that you don't do or fail to do. And it was the launchpin for consumer protection laws around the world, particularly in Commonwealth countries, but there's certainly other countries that look at this and then implement their own consumer protection laws. Minority, those two judges that didn't agree, they just said that if this was extended too far, then many people would be able to make claims against manufacturers. And that's what lawyers often worry about, is opening the floodgates, as it's called, to lots of cases. And I guess they were right to worry about this. And I think personally Lord Atkin would roll in his grave if he could see how far this law has widened and what it encompasses nowadays, because he actually had quite a few caveats in his speech on how it should be used and how he felt it should go. And unfortunately, this rolling stone just continues to widen and widen. But it's often claimed that this was actually a hoax, that there was no snail and it was actually a test case and the facts didn't happen at all. I guess we'll never know, because Stevenson never got his day in court. And at the end of the day, it doesn't really matter whether there was a snail there or not, because it's the law that matters and the circumstances. The facts don't really matter. What matters is that she was presented with a bottle. You couldn't see inside it. You couldn't see a dead snail. And so in circumstances where you're presented with something where you can't reasonably inspect it to see if there's a dead snail or a dead mouse that's very skinny inside it, then the manufacturer should owe you some sort of liability. The whole principles in the Donahue and Stevenson case go well beyond that brief summary that I've given you, but it's far too much for this short video to tell you about a snail and a bottle and a determined Scotchwoman. I hope you get the gist of how important this case is and how important May Donahue is. Anyway, Leachman never had another case as famous as the snail in bottle, but he did have his son who followed in his footsteps. He became a lawyer, a solicitor general, and ultimately Lord Leachman. Mary, or May, she died of a heart attack in March 1958. She was only 59 and she died at the Garlock Mental Hospital, where she'd probably been staying for a short period of time. By the time of her death, she'd actually changed her name to Mabel Hannah, and she'd adopted the name of her daughter, who had previously died when she was just 11 days old. Remember how I said 3 of her children didn't survive? So maybe she was going through some mental illness at the time of her death. Who knows? I love May. I think she's an amazing woman, a determined woman. Stevenson's business, of course, Stevenson died before the trial, and his business was taken over by his widow, Mary, and his son, also David, and they incorporated and became a company. Wise move, because you don't want to get personally sued again. And in 1950, they sold the shares in the company, and the plant where the ginger beer was manufactured that allegedly contained the snail was demolished in the 1960s. The Wellmeadow Cafe, where the snail in the bottle was found and where May and her friend sat down for that little evening treat, was closed in around 1931, and the building was demolished in 1959. Minjella, who didn't really play a large part in this story other than pouring a drink and taking some money, he subsequently became a labourer, and he died in 1970. In 2012, I think it was, on the 80th anniversary, Mandy McIntosh, an artist or a sculptor, she used the last photo that anyone had of May Donoghue to create a bronze statue of May holding her 2 twin granddaughters, Elizabeth and May, on their christening in 1952. And she likened holding the 2 young babies there like the scale of justice, both holding those equal 2 weights. And that sculpture is in the statue is in Paisley in Glasgow. There's also a memorial stone outside where the Wellbank Cafe used to be, showing or depicting or summarising the impact of the cafe and all of these parties in this absolute story. It's funny because when May's statue was being created, her family had no idea the impact of their grandmother or great-grandmother or mother, as the case may be. They had had no idea the impact in the legal world and in Commonwealth countries of the impact of May Donoghue. The reason that when you have medical treatment and it goes a little bit off kilter that you have a right to sue. The reason that when you get hit by a car or that when you buy something and it doesn't work as intended, or you're wronged in so many ways, even if you didn't have a contract with them, that you still have rights, and they all go back to Donoghue and Stevenson. There's many other cases, there's hundreds and hundreds that have come since then, but May was the first of many, and probably the most cited case in the world in the law of torts. I hope you've enjoyed hearing about May's story and the impact that she had on the world. Whether you might agree with the way the legal system has come, it certainly wasn't what Lord Atkin envisaged, or Lord Macmillan at the time that they made their famous judgment. But it does recognise that law evolves, albeit slowly. Like when I said that it had evolved into trade practices in Australia, it took them over 40 years to do that. So it's not a fast beast, but it shows a lot of tenacity. So personally, I have always thought, ever since I found out about this case, and I could be wrong, I'm happy to be wrong, I have always thought that this case was a test case. And the reason that I think that is a lot of lawyers run test cases, particularly back in these times, because unless you were personally affected by something, you had to sit around waiting for a client to come in that had those sorts of facts before you could change the law, or if you wanted the law to be changed, you had to wait for someone to present with those facts before you could argue it. So I've always thought it was a test case. Back in those days, they didn't really have law reform commissions that sort of look at changing the laws, and it wasn't as easy to make legislation as sometimes it is now. Sometimes it's a lot harder, but back in those days, there were a lot of cases, and you'll often find that there were solicitors acting pro bono, or there were solicitors actually bringing the action, bringing the case. They were the plaintiff. And oftentimes it was because finally the facts had come their way so that they could run a case to test what the law is and see how far it could be widened or interpreted, or maybe in the case of Donoghue and Stevenson, make new law. So that's it for my little story on May Donoghue. I hope you enjoyed this change of tact. But when I seen the snail in a Scottish woman's book, I just had to tell you about one of my favourite stories. Make sure you always check your ginger beer bottles before you drink out of them, and anything else. You know, this whole problem could have been solved just by two things. There would have been no snail in the bottle case if Stevenson had used clear bottles, if it was his bottle, and if May had paid for her own Scotsman's float. But we'll never know what the end result would be if that had happened. So that's it from me. Until next time, stay safe and happy colouring.